Lord Sumption will summarise the conclusions of the court.
Dr. Williams has a claim against the Central Bank of Nigeria. He claims that he entrusted $6.5 million to a dishonest English solicitor who fraudulently pocketed $500,000 of it and paid out the rest to the bank without his authority. Money held by a solicitor in his professional capacity is generally treated as being held in trust. Dr. Williams's case is that the bank helped the solicitor to dispose of the whole $6.5 million and itself received $6 million of that sum, in each case knowing that it was being dishonestly paid out by the solicitor. If that is right, then the law will treat the central bank as a constructive trustee. In other words, it will treat it as if it were a trustee of the funds for Dr. Williams and allow Dr. Williams to claim against it on that basis. At this stage, the facts have not been found by any court. The question is whether, assuming in Dr. Williams's favour that everything that he alleges is true, he has a good claim. The problem that has given rise to this appeal is that 28 years have elapsed since the events in question. The bank argues that the claim, even if justified in principle, is time-barred. It is brought too late. Limitation has been part of English statute law for some 4 centuries. The current statute, the latest of many, is the Limitation Act 1980. The Act provides for a general rule that personal claims may not be brought in an English court more than 6 years after they arose. The concept is simple enough, but it is subject to important exceptions which can give rise to complex and technical issues of law. One of these exceptions is to be found in Section 21 of the Act, which relates to actions to recover trust property or in breach of any trust. Section 21 provides for the standard limitation period of 6 years for such claims, subject to 2 exceptions. The first relates to claims by a beneficiary under a trust in respect of any fraud or fraudulent breach of trust to which the trustee was party or privy. The second relates to claims by a beneficiary to recover from a trustee trust property or its proceeds in the possession of the trustee or previously received by the trustee and converted to his use. The question on this appeal is whether either of these exceptions applies. By a majority of 3 to 2, the Supreme Court decides that neither of them applies, with the result that it is now too late for Dr. Williams to claim against the bank as a constructive trustee. The reasons are set out in judgments by myself and by Lord Neuberger. In summary, the exceptions in Section 21 do not apply because a constructive trust is not a true trust. The expression constructive trustee covers 2 completely different situations, and much confusion has been caused in the past by failing to distinguish properly between them. The first is the situation where the defendant has in practice acted as a trustee, although not formally appointed as such. Such a person is a true trustee. The assets are lawfully vested in and controlled by him, and he has all the same duties to respect the trust as trustees formally appointed. The second is the situation where the defendant has never purported to act as a trustee, but is simply a wrongdoer, taking the money or other assets or helping a true trustee to do so. A person in that category exposes himself to remedies at the hands of a court of equity, as if he were a trustee, although in fact he is not one. Historically, true trustees were never entitled to raise a time bar against their beneficiaries because their possession was perfectly consistent with the trust. With wrongdoers who got involved with other people's breaches of trust, however, it was a different matter. Limitation has always applied to them, just as it applied under other sections of the Limitation Acts to people who wrongfully took property which was not subject to a trust. Since 1888, the Limitation Acts have relieved true trustees, provided that they are honest, of the harsh rule that they are liable to their own beneficiaries without limit of time. But third parties, who are not true trustees but got involved with other people's breaches of trust, were and remain entitled to the benefit of the 6-year period of limitation. In this case, if Dr. Williams's allegations are true, the solicitor was a true trustee, but the bank was not. The bank is therefore entitled to the benefit of the limitation period. Dr. Williams has an alternative argument. He says that even if the bank is not a true trustee, it comes within the first exception in Section 21, which applies to actions in respect of any fraud or fraudulent breach of trust to which the trustee was a party or privy. The argument is that his action against the bank is an action in respect of the solicitor's fraud or fraudulent breach of trust. This depends on whether an action in respect of any fraud or fraudulent breach of trust means an action against the fraudulent trustee himself, or whether it can also include an action against a third party who got involved in the fraudulent trustee's breach of trust. The Supreme Court has decided that the first meaning is correct. That is to say, that an action in respect of any fraud or fraudulent breach of trust means an action against the fraudulent trustee, not an action against a third party who is also involved. The rule is perfectly simple. It is that in any action by a beneficiary against a true trustee, the trustee is entitled to the benefit of the 6-year period of limitation, unless his misapplication of the trust funds was dishonest. The exception has nothing to do with third parties. It follows that the constructive trust claims by Dr. Williams against the bank must be struck out as being out of time.